Welcome to Rebel Chaser. My name is Gail, and I have a clip for you from Judge Hayward in Georgia. She is hearing a termination of tenancy, and this mom is very greedy. I'll just let you guys watch.
All right, so First Key Homes, do you have someone who's going to present the evidence on your behalf? Do you have a witness?
Yes, Ms. King is here. Ms. King,
Okay,
can you turn your video on?
Oh, yeah, sorry.
I'm gonna need you to screen share some exhibits, okay?
Okay, give me 1 second.
All right, raise your right hand for me, Ms. King. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you could put your hand down. Your witness, Mr. Bolden. Ms. Player, once Mr. Bolden has presented the evidence on behalf of his client, then you'll have the opportunity to ask any questions that you may have of the witnesses that he presents, or to present any evidence with respect to your answer or counterclaim. Okay?
Okay,
All right,
Ms. King, we're gonna start first with Plaintiff's Exhibit 1, which I've already submitted to the court, which is gonna be the lease.
Okay. Let me pull that up.
Pull that up. And while you're doing that, if you would just introduce yourself to the court and let the judge know your association or affiliation with First Key Homes.
Yeah, I'm Talia. I'm a property manager with First Key.
Okay. And are all the exhibits documents we're going to discuss today kept in the ordinary course of business with First Key Homes?
Yes.
And you have access to those records and have personal knowledge of those records based upon your review of those records. Is that accurate?
Yes.
Okay.
I got the lease right here. Give me 1 second. Okay. You want me to share my screen, you said?
Mm-hmm.
Okay. So I'll share this one. This is the lease that we have in file.
Okay, and specifically, is that the lease in connection with Audette Player and Ricky Player?
Yes, their names are.
They're on page 2?
Yeah, right here.
Okay. Specifically for the address located at Hondal Court, Hampton, Georgia, 30228.
Yes, sir.
And is that the subject premises that we are seeking possession of today?
Yes, sir.
Is that located in Clayton County, Georgia?
Yes.
Okay, and if you would, what is the term of this lease? I believe you'll see it there at the bottom of page 1.
The term for this one looks like 8/31/2020. This is just for the rent. 8/31/2020 to 9/7/2021.
Okay, the version that I have, the term commences on September the 8th, 2022. Are you able to pull that one?
Yeah, let me look for it. Give me 1 second. You said it started in 2022?
Yes,
Okay.
September the 8th. There we go.
Yeah, there we go. My apologies.
There you go. Okay, perfect. So the term of this lease is 9/8/2022 to 9/11/2023. Has there been any other renewals or contracts or leases between the parties since that time?
I don't believe so.
Okay, and is the is First Key Homes, they are the managing agent for this property. Is that accurate or not?
Yes, that is.
Okay. And if you would scroll down to the end of the lease and just show the court the signatures and let the court know when this lease was signed.
So the first set of signatures we have for the lease in general says it was signed by both residents on June 17th, 2022, and it was countersigned by us on June 21st, 2022.
Okay, thank you very much. And what is the base amount per rent, per month for rent at this property?
That would be 2035.
$2,035 to be specific?
Yes, sir.
Okay, and I'm kind of catching you off guard here a little bit, but do you know when the last time that rent was paid?
I can check the ledger. It's been well over, I think, months.
Yeah, let's pull the ledger up.
I'll put this over here. Okay, this is the ledger as of today. The last time any payment was received was on December 1st, 2022 in the amount of $4,445.
Okay, and that left a remaining balance of 2310.89.
Yes,
even
sir.
after that payment.
Mhm.
Okay, and so what is the total amount that we are seeking today based upon that document? And this document is the ledger of the account for the address at 10959 Honda Court in Hampton, Georgia. Is that correct?
Yes, sir.
Involving Audette Player and Ricky Player, the defendants here today?
Yes.
Okay. What is in this document, was this document kept in the ordinary course of business
Yes, it is.
with First Key Homes? Okay. What is the total amount we're asking the court to grant today as a monetary judgment?
The total amount due in the ledger today, including November's rent, is $64,696.
What would be the amount just through today?
Through today, which is,
Yeah,
I guess, $62,000, $62,086.
$62,086. Okay. And this ledger includes additional charges such as utilities in the ordinary course of business. Is that
Yes.
correct?
Yes, sir.
Such as electric, water, stormwater, insurance non-compliance fees, and month-to-month fees. Is that accurate?
Yes, sir.
Okay, and are those fees that I just listed set forth in the lease agreement between the parties?
Yes.
Okay. So, Your Honor, this would be Plaintiff's Exhibit 2. We'll go ahead and move to admit Plaintiff's Exhibits 1 and 2, the lease and the ledger.
I have a question.
I'm sorry, was that
Oh.
Your Honor, was that
Yeah,
you?
it was me. I have a question.
Okay.
So my question is, the amount owed, the first amount was $64,696. But when you said through today, it changed to $62,086. What's the $2,000 or thereabouts? What's the difference?
So the original figure, the 64,696, that includes November's rent because November's rent's already posted. But through today, October 30th, it's 62,086.
All right. That was my concern. All right, thank you.
Okay.
All right, so Miss Player, Mr. Player, the plaintiffs have offered their exhibits for entry into the court's record. Do you have any objection to anything that's been testified to with respect to these records?
I do object, Your Honor. And I do have questions. So should I object and go with why I object first, or should I ask my questions first?
Okay, so is your objection that the records are not the records that were kept in the normal course of business, not specifically as to whether they're correct as you see them to be, but do you dispute that these records were kept as business records by your rental agent?
I object that the amount is wrong for
Okay.
the amount
That's
that was
different.
paid in December. Okay.
All right. So, but these being records that were kept in the normal course of business, we can
Yes,
talk
that is
about.
correct.
Okay. All right. So that exhibits 1 and 2 will be admitted with the objection noted that the defendants believe that the amounts attested to in the records may not be correct. Okay.
Yeah,
All right.
that's
So exhibits 1 and 2 will be admitted. All
Okay.
right.
Okay, Ms. King, if you would please pull up the demand notice letter.
Okay. 1 second.
And that was, it would be dated August the 8th.
August 8th.
Yes, ma'am.
What year? Just so I know.
2023.
Okay, it's just from right here.
Okay, do you recognize this document? And can you please identify it and describe it for the court?
Yes, this is a demand letter. It's the demand of rent for non-payment. This is what we send to residents before we file.
And this document has been kept in the ordinary course of business with First Key Homes.
Yes, sir.
And when you said this would be the letter we sent out for non-payment, specifically, was this letter sent out to the residents at 10959 Hondle Court, Hampton, Georgia 30228, on or about August the 8th, 2023?
Yes, sir.
It would be the ordinary course of business and practice of First Key Homes these would be automatically generated when a tenant gets behind and sent out to the tenants. Is that accurate?
Yes, sir.
Okay, and in this instance, at the time when this letter was sent out, how does First Key send these notices out?
It's through certified mail, so it goes straight to the property.
Certified mail. And at the time when this was sent out, what was the balance that was owed as reflected on the account at that time and in the letter?
Looks like it was $21,843.25.
And again, that was not paid, and no monies have been accepted from First Key since that time period. Is that accurate?
Correct.
Okay. Do your records show there was any attempt to make that payment in full?
No.
And subsequent to this letter, it indicates that there's 3 days for them to pay in full. Is that accurate?
Yes.
And subsequent to this letter going out, the tenant's not paying in full, is when First Key Homes, through its attorneys, filed the instant claim, dispossessory action, seeking monetary damages in possession of the subject property. Is that accurate?
Yes, sir.
Okay, Your Honor, plaintiff would move to admit the demand letter notice on the screen as plaintiff's exhibit 3.
Any objection to the demand letter, Ms. Player?
No objection, other than I never received that certified mail, and if so, I would like to see a signature for a receiver for certified mail, please.
Okay. So exhibit 3, the demand letter will be admitted with the objections noted from Ms. Player.
Okay. Lastly, Ms. King, the crux of the tenant's answer in this case essentially surrounds, and I don't want to misquote it, but essentially surrounds the belief that there should have been some kind of credit applied to the account. Can you pull up and this was already duly admitted, attached as an exhibit, Your Honor, to the tenant's answer in this case. But Ms. King, if you could pull up the ticket confirmation number of the credit that was at issue during that time.
The confirmation number?
Well, there's a confirmation letter that I have here that it says that, a credit was issued, ticket number 1262126.
Okay, let me pull that up. Give me 1 second.
Who gets to determine when the old ends and the new begins?
Count that number one more time. I'm sorry.
It's 1262126.
126 2126. Okay. I got it. Give me 1 second. Can y'all see that?
Yes, ma'am.
Okay.
Okay. And essentially, I may be catching you off guard a little bit, but this document that we're looking at, can you just describe it for the court as far as what this is, as far as
Yeah.
internal?
So it's just a download of a ticket from Zendesk. Zendesk is the platform we use to communicate through email with our residents. So this is just the summary of that, and it shows everything sent and received.
Okay. And so in this instance, would this represent the credit that Miss Player is referencing that needed to be issued in her answer? Is that what this involves?
Yes, I believe this includes the confirmation that we issued credit. Review process.
So this is all these communications are between First Key Homes and Miss Player. Is that accurate or not?
Yes.
Okay, so if you would just close this window and pull the ledger back up.
Okay.
And once that's open, would you please share your screen on or about the month of September 2003?
Okay. 2023.
2023, yes.
That would be right here.
Okay. Are you able to zoom in a little bit at all?
I might have to download it to that, and I can't.
It's okay. Your Honor,
Okay.
are you able to see this okay?
Yes.
Okay. And if you would, Ms. King, can you please read the itemized line for September 21st, 2023?
Yeah, this was it says concession for multiple maintenance issues in the laundry room, replacing the carpet. All AMG was removed and the area was dry. Has the corresponding work order numbers.
Mhm.
This was approved by our regional VP, and then it has the ticket that we submitted to accounts receivable to put it in.
And what was the amount of the concession that was issued?
$2,035, so 1 month's worth of rent.
Okay, 1 month free rent. And what does all AMG was removed stand for? Do you know?
AMG is what we call organic growth. So any
Okay.
organic growth that comes from water damage.
Okay, perfect. Are there any outstanding work orders
Not that I
placed by
saw.
Mr. or Mrs. Player in connection with this property?
Not that I saw, but I can pull them back up just for that confirmation. I'm not seeing any that are open.
Okay. Um, Your Honor, we would move to admit as plaintiff's exhibit 4, the internal work order that seems to be the underlying basis of this dispute. I did not send that to the court. I'll be glad to do that.
All right. Any objections, Ms. Player?
No objection, other than the fact that there are open work orders that have not been filled, because of course we are not under lease and they have not come to fix. So I do object to that, and I object to that being the amount of the credit as well. So I don't know how you want to word that, but that is not the amount of the credit, $2,000. So I guess I'll have my time to speak.
All right.
So, Your Honor, again, just to recap, the plaintiff is seeking a writ of possession to issue within 7 days. And the total balance after that 7 days is that first figure we gave you, the $64,696. Ms. King, is that accurate?
Yes.
That figure is accurate?
Yes, sir.
64,696. Okay.
Yeah.
Nothing further, Your Honor.
Well, there's one thing further. Y'all haven't told me whether they're still in possession of the property or whether we're just arguing about money.
Yes, I'm sorry, Ms. King. As far as you're aware, is the property still being occupied by the tenants?
Yes.
They're still in possession?
Yes.
Okay. That's
All
all.
right. All right, Ms. Player, did you have any questions for Ms. King?
Yeah, I have several questions for Ms. King. How you doing, Ms. King?
I'm good. How are you?
Well, can I ask you when you started working for First Key Homes, please?
My first day was, I believe it was September 23rd, so last month.
Oh, you just started last month. Okay, so
Yep.
September 23rd, 24. Okay, so are you is Alyssa Hayes, which is the property manager, is she still the property manager of 10959 Honda Court?
We don't have, we have property managers. We don't have specific portfolios, so we're not assigned to a specific property, but she is still one of the property managers with us, yes.
Okay, do you know if Simone Kennesaw, Kennebrew is still a manager at First Key Homes?
Yes, ma'am, she is.
Yeah.
Okay. Okay, I'm sorry. I thought I heard something. I'm sorry. So are you aware of the black mold poisoning that was found in my home, in my daughter's room? Are you aware of?
Your Honor, I'm going to object to the question. There's no foundation for that.
I'm asking based off of the
Hold on.
evidence that you supported.
Mr. Bolden, we just have a discussion about AMG, meaning that there was an organic, something organic found that was caused by water?
Yes. Yes, Your Honor.
Seems her question is valid based on the testimony posed by Ms. King.
Well, there wasn't anything said about black mold.
Well, AMG and
or
caused by water by any other term is mold. It might not be black mold, but you telling me that it's not mold that we're talking about?
No, I'm not saying that. I'm not at all. I'm suggesting
It's a
that
reasonable
wasn't anything
inference
brought
from
up.
the testimony given.
Okay.
All right, go ahead, ma'am.
Okay, so I'm asking, are you aware of the black mold poisoning that was found in my daughter's? I'm sorry.
Sorry.
In the walls, in the floors of my daughter's room at 10959 Honda Court?
Yes, I was aware of the AMG
Okay.
issue there.
And were you aware that we were asked to bring in all of our supporting evidence to you and your legal team at the corporate office?
Yes.
Okay. So based on the information that you presented through the emails that you presented, you have emails that look like my emails. And so those are the ones that I printed out. So
Okay.
based off of what you showed in the conversation, did you see an acknowledgement that they were working to give me the credit for my daughter's medical bills and for punitive damages?
Yes, the credit you requested.
Okay.
Yes.
So also, I have another question for you
Okay.
based off of your testimony. And you said that in December that I paid an amount of $4,000 and there was a balance left of $6,000.
I'll go back up to that.
Yeah, it was in the ledger. I think you said I owed $6,000 after paying 4,000 something.
You paid $4,445, and what was left over was $2,310.89 once that was applied.
So it's like late fee, utility fee, and some other fee. Okay. So you're saying I owe $2,000 after the payment was applied, and that looks like December the 1st. There was $2,000. Okay. So then is it accurate then by May 11th that by that time I owed 10,000, let's see, $10,175 by May 11th? Would that be accurate?
2023 or 2022?
2023, I think. Yeah, 2023.
In May of 2023, I don't see anything specifically for the 11th. I have entries
Or on
for
or around.
yeah, so around like the 6th, it was $14,564.45.
Okay, that I owe. Okay, so is it also true that you guys filed eviction at that time for the amount owed that's filed with the court for $10,175?
I'd have to go back. I know there was one filing before this one, so
It
that's
was,
what.
yeah,
Yeah,
that's the one I'm referring to. So it's the date of, it says the date you guys filed it would be May 3rd, 2023. That might be why it's less than the 14,000 because it shows $10,175.
gotcha.
So,
Okay.
okay. And so are you aware that you guys voluntarily dismissed that and said that you filed it in error?
Yes, ma'am.
Okay. So based off of the evidence, and then if it was filed in error, then does that mean that I owe the 10,000? I'm just trying to figure out because it said that it was a voluntary dismissal. Now comes the above named plaintiff and hereby voluntary dismisses the above matter against the defendant without prejudice filed in error this day of 5/11/2023. Is that not correct?
Was it dismissed? Yes, it was dismissed.
It was dismissed and it was noted that you guys said that you filed it in error.
Your
Okay,
Honor,
so I
yeah,
just
we
wanted
we
to I want to
stipulate there
make
was a
sure
Player,
prior.
that
Miss Player,
I'm sorry.
dial it back a little bit, ma'am. Yeah, it was dismissed. Okay, what's the point?
It was dismissed because it was filed in error. So the point is, you guys
Okay.
had an understanding that I didn't owe 10,000, and that the credit that you guys were going to apply, you had a credit to apply, and if I owed $10,175, then we
Is
know
this
that the
a is
credit.
this a question for the
Okay, so
witness or?
I thought
so
you asked what the
King,
point.
Miss King, did
Yes.
okay, so at the time of the last dismissal, did they
Yes.
still owe money?
Yes.
Okay, do you know how much money they owed at the time of the last dismissal?
It says 5/11. I can only attest to what I can see closest to that date, which is on 5/6. That was $14,639.45.
Okay,
Like Ms. said, since it was filed earlier than that, that's probably where the $10,000 came from.
okay. So at the date that it was dismissed, there was still money owed.
Yes. A dismissal doesn't mean that we wiped the balance. It just means that it was an error internally. We just dismissed it for that.
Okay. All right, go ahead, Ms. Player.
Okay, so then I'll also ask you again, on or around, give me 1 second. And can you also give me the last date while I'm looking at this? Can you give me the last date based off of your emails of the email conversation we had concerning the credit? What was the
Last date?
wait a minute, I may have it. May 11th. So Yeah, on the last date, May 11th, one of your emails had May 11th from Melissa Hayes.
Mhm.
That was the same day that it was filed, it looks like, at the court, where there was, based off of your evidence and mine, to please accept the sincerest apology for the time frame taken to determine your credit request. Do you see that?
I'll pull that back up. Give me 1 second.
Okay.
You said it was with Alyssa?
Alyssa Hayes.
Okay.
And it was in the evening. Well, it said good evening, but it's 12:40. Oh, well, it was 12:48 a.m. in the morning, actually. Wow, didn't even really realize that.
1 sec while I pull it up. I'm not seeing that specific email, but let me just keep looking through.
Okay. Well, we'll move on. I have submitted it in evidence. It should be somewhere on
I see it now. I see it on May 11th. Yes, I do see that.
Okay. So then also, after that, I received a notice in the mail for a renewal of my lease. Also, it will be an increase. Are you aware of the letter that was sent to me to actually renew the lease? Because at this time, we're looking at, let me see the date of the letter you sent for the lease renewal, because we're going to see how much I owe.
Okay. Let me pull it up in your attachments.
1 second, I got so much. Just give me 1 second and I'll give you the lease. Okay, this is 6/20/2023. Did you not send me on June 20th, 2023, a notice of rent increase and from First Key concerning my lease to renew it on June 20th, 2023?
June 20th?
Yeah, June 20th, 2023.
Let me see. Might be in the memos. We have a renewals team that reaches out, so it probably wasn't one of the PMs, probably was renewals. But
Okay.
I will leave memos because they leave notes.
Well, I can make sure that I scan this in so that you can have a copy of this invitation to renew my lease. Can we look at the ledger real quick?
Ma'am,
Yeah.
what's the
Yes.
point of the lease renewal?
The point of the lease renewal is that even at June 20, 2023, I want to see the ledger and the amount that was owed at that time, since she brought up the ledger, because they offered to renew my lease with that amount still, quote unquote, outstanding. They were full aware that I didn't have an amount outstanding and that they were supposed to compensate and clear my debt. So this is also evidence that they even offered me to stay after, let's see, 6/20. It says I owe $49,000. Is that 6/20?
That was 2024.
Oh, 2020. Okay.
Yeah.
So 6/20, it looks like I owe 17,224. Is that right?
Yes, that's what I'm seeing.
So then at that time, I was offered to renew my lease at that time. Also, they filed again now at bringing it current. So we're looking at September at this time for 18,000.
Okay, Ms. Player, can I ask you a couple of questions? So I'm looking at the ledger.
Hold on 1 second.
Is it your contention that the issues with the apartment made it such that they would wipe your total debt clean?
Well, that is what the consensus was, and even and see, the question really wasn't about the amount of the rent owed. Even with the last attorney, they were clearing the debt. The problem was they wanted me to move after they had already said that I could stay there. So I said, "Well, you're
Okay,
clearing the debt, but
wait. Let me ask you, do you have something in writing that where they said the amount of the debt that they meant to clear? Like they're gonna give you a credit for $17,000, or they're gonna go ahead and wipe 17,000 or credit you 17. Do
well,
you have no, well, listen to my question carefully.
yes, ma'am.
So first let me explain why I'm asking you this, because I don't want you to think I'm beating up on you, but a lot of people who are not from Georgia come from other jurisdictions, and the law is very different in other jurisdictions. In Georgia, as long as you are in the property and in possession of the property, you owe the rent and fees that are due that come with possession of the property. Now, if you have an issue where it's a repair issue or a remediation issue, and you've given notice to the property owner, the landlord, and they have failed to ameliorate the problem, if they haven't fixed whatever it was supposed to be, then you have the opportunity to pay for those things to be fixed, and that would be a credit offset against your rental amount that is owed. If they choose to give you a credit, that's fine. They're not required to do that. But if they do so, it should be in writing somewhere that they've given you a credit equal to a certain amount of money. Now, do you have something in writing that says they gave you a credit, not what you all discussed, not what should have been agreed, but something in writing that says they were going to credit you a certain amount of money?
The only thing I have is that they were going to give a credit, not the dollar amount. But I will say in court,
So, because
when we
here
were
it
at
shows
court,
that
he said it. Does
they
that make a
credited,
difference?
well, here it says they credited 1 month's rent. But if you're arguing that they should have wiped your debt clean,
That
I'm
is
going
what
to
they
tell you,
in court.
I've been doing this since magistrate court since 2012. I've never seen a landlord say they were going to wipe a debt clean.
They said it in court. The last court hearing that we had, he said it in court that they were willing to wipe that because they really didn't want to be countersued for
Okay,
the amount that
if
they could be. They said it in court that they
if
was going
they
to
were,
wipe the entire debt
did they
clean.
say if they wipe the debt clean, you have to leave?
They want to, yeah, they do want me to leave.
Okay, so that I understand. So what they're saying is they want possession of their property. They want you
Right,
out.
right.
They don't, at this point, they don't think they're going to get their money. And I'm speaking for Mr. Bolden, but Mr. Bolden can correct me when it's his time to speak. But I've seen this before. I've not seen what you're saying, that they wiped your debt and then you get to stay. That never happens.
Well,
No,
that,
no, no. Listen to Miss Player.
yes,
They
ma'am.
want their property back
I
because
get
they
it.
want somebody who's going to pay the rent.
I
You've
get
been
that.
living rent free since 12 since December 1st of 2022, which means they've lost a whole year, almost a whole year of rental income. So if you will agree to leave, they'll say, okay, we're not even going to pursue the potential judgment that we could get from you. We just want our property back. But you want to have your cake and eat it too, which is, I want to live free and stay.
Ma'am, that's not what I want. What I want is justice. What I want is they harmed my daughter. My daughter had to drop out of school. I have submitted medical bills, which they have the medical bills. They were fully aware of my daughter's illness. It
But
was not a
ma'am,
question of if
Miss
it was
Player,
black
Miss
mold or if
Player,
they made
Miss
my daughter
Player,
sick.
This player,
Yes, ma'am.
everybody in a civil suit who alleges damages has a responsibility to ameliorate those damages and mitigate those damages to the best that they can. So I'm going to tell you, in a civil suit where your counterclaim is for damages done to your daughter because of a mold infestation, you have the responsibility of lessening those damages, but you chose to stay and you had to pay. Listen to me. You hadn't paid rent, which means that the rent you should have been paying, you could have been accruing and moved to another place. But instead of doing that, you stayed didn't pay rent, your daughter was in an unhealthy situation, you didn't mitigate the damages in any way, and now you want to stay in a place where you claim it's unsafe. You want to stay there for free, and then you want to sue for damages that you didn't lessen when you could have had the money that you didn't pay for rent in order to move to a different place. You could still
Ma'am, I
sue.
could not move. I could not move because everywhere that I tried to move to would not move because it looked like I owed these people $18,000 when they said that they would give me the credit. It clearly says in writing that they would give me the credit. You see that I was quote
Ma'am, I
unquote
didn't,
owed $10,000 and they dismissed it for filed in error. They know that I didn't owe them the 10,000 because they
I
had agreed
saw
upon
a
it.
credit, but I didn't see anything that you've produced that said that they were going to wipe your debt clean. There's nothing in writing, man.
And it doesn't matter that it was said in magistrate court either.
The magistrate court is, I mean, they record cases. I don't know if they've recorded it, but the judge there should have recorded that somewhere on the documents that you were getting a credit. But if that happened in magistrate court, why are y'all here? Like, why is
because
the
I
case
had
here?
because I had a countersuit on the matter. I had a countersuit on the matter. So because the countersuit was more
So
than
they were
fifteen
gonna,
thousand dollars, we
they were
had to
gonna,
move.
what's the countersuit for?
The countersuit was more than $15,000, so we had to move from magistrate to state according to that judge.
So they had
And
agreed to
so
wipe
we've
your
been waiting
debt.
to get on your calendar for
Okay,
6 weeks, and I
Ms.
couldn't
Player,
move.
I'm just trying to tell you what it looks like and what the law says. So you gave up the opportunity to have the debt wiped to just move out of the property because you think you'll get more by suing for the counterclaim. But
But
what I've
that's not true.
explained to you is with the counterclaim, you have a duty to lessen the damages. And if you stayed in a place where your daughter was suffering, even though you didn't pay rent for a whole year, so you should have had $2,035 times however many months to move, I would you stay in a place even if you had difficulty moving? Why would you stay in a place? Because you can rent a house from a person, a property owner, an individual landlord, if you walk up to them with cash. Now, this I know personally. Cash in hand gets you save money by not paying from the time you stop paying through today. Sue for something that you had a responsibility to lessen your damages. That's in
Well,
the law.
well,
You're
ma'am,
trying to stay in a property where they've already said, just leave because we'll wipe away whatever's there. But now you're saying that because they said that, you want them to wipe it away and you
mhm.
stay. And that's just not going to happen.
I'm feeling like I'm not able to explain myself, and I haven't even begun to speak on my countersuit. And I feel like it seems to me that you kind of see something and you got an image in your head based off of previous court hearings or court cases, and that's not the case in this
No, I'm just
situation.
explaining to
And
you
I'm
what
telling
the
and
law
I'm telling
is,
you that
ma'am.
well, I'm telling you that I was not trying to sit there and live rent free. I wanted to leave from the property and was unable to leave. I can submit to you in your office places where I was denied, where I've never been denied a place to live based off of the fact that it looked like I owed these people. They know that I didn't owe them that amount of money. That's why they filed it in error. And you see the apology letter at 12:48 a.m. on May 11th, the same day that it was filed in your office at 12:48 a.m. They're apologizing because they knew that I did not owe them that money. I'm not sitting here just trying to live somewhere rent free. We went to court and it took this long to get on the calendar, but what I could not move. It put me in a position where I could not move. And the house is not still secure because it's still raining in the house. It's still mold and everything else in the house. I am stuck in an environment where I can't go anywhere. And so
Okay, let me ask you this. So I understand that they did some things. On here it says that there was work orders and some work was done. But you're saying that there's water still coming into the apartment.
it's not an apartment, it's a house. And yes, from the upstairs, they
Okay.
came again. They did come again for upstairs because once I
Okay.
moved my daughter from downstairs, we moved all her stuff from the downstairs area because it's downstairs area. We moved her all the way up to the north this side of the house. And then
Okay.
probably, I don't even know, weeks after that, the water started coming through there in the carpet. So they came and they did find mold again in the house, and they moved, they cut out the ceiling, cut out the carpet. All this time I'm trying to move. Not only this, I take care of my mother who is bedridden in the hospital, has a nurse 8 hours a day in that house, physical therapist, occupational therapist, who's in the front area of my house. I I take care of. She couldn't scratch her nose if she needed to. Like I do everything for my mother. So when that being said, I did not want to be in this environment. I felt stuck in this environment. And so I could do nothing but wait. And I
Okay,
was
one
going
more question.
actively calling and actively coming to the court.
I got
I'm
you.
not sitting, I'm actively coming, like trying to get the court date, trying to figure out what we do, because I'm trying to get out of this place. I'm not just trying to stay in this place.
Okay, question. Since you said it's a house and they haven't been able to fix the problem, did you call in a company, not them, but did you find a company or call in a company to come in to assess the problem or to give you an estimate of what it would take to fix the problem if you
Uh,
paid for it?
the last person that came that fixed the wall, and they said it's in the house, it's internal, it's in the pipes, it's in the structure. There's nothing we can do about that house. Even if they would probably have to tear the house down or do something because it's internal. So it's going to go
Did
from
they
one
give
place to
you
the other.
did they give you something in writing that said that?
No, but I mean, if I would have knew that I need to get that in writing, like I mean, I guess we could call the people back, but that's what they said concerning. They said it didn't matter because even with them fixing this and pulling up the carpet again and tearing out the walls again, that it was going to continue from place to place in the house. There was just nothing I can do about it. My mom is literally right underneath my door. So I care about the well-being of my family and especially my elderly mother who is literally hospital bedbound. So I'm not
Okay.
just kicking it in this house. Like, what do they call those people? I'm not
What
one of those
no, I'm
people.
not. What was the name of the company that you called to do that assessment?
Whoever the first piece sent out there.
No, no. So you're not hearing me. When First Key fails you and they fail to fix the problem, then you have the right to call somebody in yourself, separate from what they're doing, and ask them to assess the problem and pay them yourself. And then under Georgia law, that would work as an offset against anything that you would owe First Key. So say
Well,
First Key said, hold on. First Key says you owe $40,000 and you call in a company and that company says, well, it'll take us, if we can get this fixed for about $18,000. You get in like a list of things that need to be done and you pay them to fix that because you're not paying the rent, you know that money's accruing. But if First Key then comes to court and says, well, you owe $40,000, you have a company that says $18,000, we fixed the problem, here it is, here's the bill that I paid. Then you give it to First Key, that sets an offset against what you would owe. So that would be your credit. Like if they don't choose to give you a credit, you can have the property fixed and then that becomes the credit against what you would owe them. Were you ever able to call in anyone to do that?
I didn't know to do that. I went off of the word of the guy who came to fix it. He said, because when it happened downstairs and they
Mhm,
did all the stuff and I moved my daughter upstairs, months after
mhm,
that, it happened upstairs. And so when they came and we said, okay, for this is going from room to room, he said it was internal, it was in the pipes, it was in the walls. It didn't matter that wherever it's in it's in the walls of the house. It's nothing that they could do about it. Like they can fix it temporarily, but it's going to happen somewhere else. And what you did, because then it went downstairs in the front area when you first walk into the house. And then now it's in my kitchen above my kitchen sink. So it's been just bouncing around. And once again, I'm stuck in this matter. It's not like, I mean, I can't move because it looks like I owe these people. No one wants to rent to me because it looks like I owe them all this money. They said they would give me the credit. They knew, and they were giving me the credit based off of my daughter's sickness and illness and those things, not based off of the inconvenience of having the mold in the house or having the walls wide open for months at a time. Like that's not why they were giving me the credit. They were giving me the credit based off of my daughter. And we see that they acknowledged that they were going to give me a credit. They said they were going. We know that they dismissed it for 10,000. They turned around and instead in court that they would just go ahead and get rid of the 18,000. And I'm like, well, I can't move in 7 days with my mom. I have a whole medical team that I have to move. I have to get in contact with Coweta County to do all of that stuff. And plus, who said 18 that my daughter, look what you did with my daughter. Does that not have any bearing?
So
So
the
it
eighteen
because
thousand, the
Yeah,
18,000 credit you said would not have been enough, which is why you held on for this court date. What is it you claim that for your counterclaim? What is it that you claim that you're entitled to?
I wanted at that time the amount cleared, which would have been the 18,000, but I would have needed at least 60 because that was the amount that was owed. I said, even in my answer, go
Mhm.
ahead and clear the amount owed and give me 30 days to get my mother into another location because when me having my mother having legal guardianship over her, I have to let Coweta County know before I move somewhere. She has a whole medical team with physical therapists and occupational therapists that come in. I have a nurse 8 hours a day. I would need at least 30 days and to be able to clear the debt, and I need at least 30 days to be able to get my mom's medical team and everything else Coweta notified. And I don't mind moving because I didn't have a problem. I didn't want to live there. But he said,
Okay,
oh
so
no,
let me
you
ask
got to
you
be
this.
gone in 7 days. I said, I can't move my mom in 7 days.
Okay.
Well, then forget it. And so then the judge sent it over to state court because the countersuit was higher than 15,000.
Yeah, because judges can't, like, the most we can give is 7 days. If you all can't work something out beyond 7 days, that's the maximum allowed by law that a judge can order in an eviction. So I understand that you have issues that, your mom's health care is a little bit more complicated, but even if they say no 7 days, then we're bound by that because that's what the law says. We can't give you more time. Y'all can agree to more time, but we can't give you more time. And so if
Well,
they're unwilling to agree to it, then that's how you ended up here.
well,
So
and
now
I could have
wanted,
been gone in September or October, or whatever, 30 days after the fact. I could have been gone 30 days. All I needed was time. I have to let the courts know anytime that I move with my mom because I have legal guardianship of her. And so I have to let them know. I have to be able to move the medical team. I have to be able to do all of those things. Wipe the debt clean. We'll call it even Steven. I don't even have to renew the lease, even though you guys even offered me to renew the lease, and I'm owing all this money. That's because they really knew I didn't owe all this money. What they agreed to. However, I would have been good, Your Honor. I would have been good with just giving me enough time to get my mother into a stable place and them wiping the debt. And we wouldn't even be here. I could move somewhere else, but I can't apply for somewhere. And I've never had apartment. You can look. I don't have issues like this, but because it looks like I owe them all this money, no one wants to rent to us. And I have my whole mother.
okay. So the next thing is how much are you claiming as part, so the 18,000 in the 30 days, not too much I can do about that because that happened in magistrate court. And since that wasn't solidified down there, then now your case comes up here for what is called a de novo review. So I'm looking at it with fresh eyes. So that's off the table. So what is the counterclaim?
The counterclaim is for $150,000, and that's for my daughter's illness. That
Okay.
I've submitted the documentation from the doctors, the emergency room care. She's now on nebulizers. Now she has to have an asthma pump all the time. It was really for the inconvenience.
Okay. Do you have medical bills that show actual costs, not just pain and
I do.
suffering, inconvenience, but what are your actual costs?
Well, I do have insurance because I didn't want those bills to accrue and
Okay,
make my credit go
that
down.
that that doesn't matter. Do you
Okay,
have
I got the
actual
actual.
costs that were billed to you for your daughter's care?
Yes, yes, I do.
Okay, what was the actual cost of your daughter's care?
Um, I would need to calculate it all, or do you want me to just give you every bill total on each one of these bills?
Like categories. So for the doctors, how much did you pay? For medicines, how much did you pay? For anything having to do with her illness?
So 10,000.
Your Honor, can I say that the reason behind the mode and everything else. I mean, the whole reason why we're here from the beginning is because that first key did shabby work from the beginning.
Okay, I get that, Mr. Player, but here's the thing. Essentially, you have two options. You can stay and pay, or you can leave. And so y'all have stayed long enough through all of these issues to accrue an amount owing on the rent that is huge. Had you like start looking for a place when the issues first started, or when you first knew that they weren't fixing the issues, like they've come out several times, we're not able to fix them, we need to start looking for some place to go. I get that you have your mother has medical issues and everything, but you could have given yourself time at that point to kind of find some place without accruing a huge amount of money. What I'm saying is, I get what you're saying, and I'm not saying that you're wrong. What I'm saying is, under Georgia law, this is the way it works. If you're in the property, you have to pay. If you have an issue that causes you to not be able to use your home, then that's different. Like if you had moved and said that you were what we call constructively evicted because the home was not livable, that's a whole different thing. You could probably have gotten some relief under that because you moved because you were forced out. That's a different thing. But you never moved and you kept accruing. And I get that, but listen to me carefully. The law is not. The law's pretty hard and fast. Like if you live in the place, you're owing the money. If there's a problem and they don't fix it, you can fix it yourself and get a credit against what you owe, or you can leave. I get that you want all this wiped because you don't want it on your you don't want it on your record, but the where you failed was you stopped paying your rent. Even if they had given you a credit, you would have gotten that back. So if you had negotiated successfully the credit that you asked for, that would have come back to you. But you can't stay in the property and not pay your rent. When you stop paying the rent, that's when you began to accrue an amount that was owed that was probably more than you can pay out of pocket right now.
So is this not, I mean, even with them stringing me along week by week, month by month, oh, okay, we're coming with the credit. Okay, they're looking
But
at
think
that.
about
Okay.
it though. You still are paying to live in the place. If they had given you a credit, you would have that money back. So
Well,
they
even in
credited.
our initial conversation, I mean, I just knew that because we went in person and met with these people and their legal team in person.
And
We
did they
knew then that it was more than a month to month thing. I
did
feel
they
like they did this $2,000 thing. Look at the date they posted that $2,000 credit. It was right before we went to court. Right before we went to court, they posted that just to say, oh, okay, let's put something on there because they knew what they had agreed to with me.
I get that, but if somebody agrees to something in like verbally, but you come into court and you know they're going to have documents and you have documents and they don't tell you that same thing in writing, then when they come to court, what I'm looking at in the documents that I'm looking at says that you got a credit. You got me? It also says that you stop paying your rent. If you Even if you pay your rent and you get a credit, well, you know, you're even then. You're living there, they paid you back for paying your rent. In this case, you stop paying and you want a credit.
Well,
And
not
you're still
essentially.
in
What I
possession of
want the
the
credit
property.
to the account, but I countersued. The only reason I countersued was because of the amount that they were saying that I owed. Originally, I wasn't going to countersue them. Originally, I will be honest. Originally, once they got everything fixed and they said they were going to wipe the debt clean, 30 days I'm out of the house, I wasn't going to countersue them. But then when they're like, oh, well, you have to go. No, we're not going to. I said, well, I have to get my mom out. I have to do this. Well, no. I said, but you asked me, y'all sent me a lease to renew my lease. Now you're taking back and rescinding the lease. And so it's like they turned on me when I had been nothing but doing the right thing the entire time, trusting each one of these emails. I got over 15 emails where they're stringing me along week by week of applying this thing. And then right before we go to court, they put a credit on there, which I never even knew about this $2,000 credit, or I would have brought this up when we spoke, when we went to court. it looks like they put this on right before we went to magistrate court. Then when we get to magistrate court, okay, we're going to clear the debt. That's what the original plan. You're not doing me a favor. That was the original plan. So it's like now you're going to get rid of the debt, but now you want me to go. And I was a good tenant all these other years that I've been there. And so now you want me to go. Okay, well then I need at least 30 days so I can get my mom out. No, you got to be gone within 7 days. Well, that's not going to work for me. Well, let's go. And so there we go. So I said, well, I'll countersue for what you really owe me. What you really owe me is damages to my daughter, her health, her breathing. Now she's on a nebulizer and albuterol forever, or however long it's going to last. I don't want to speak that over my child, but however long that's going to last, she's on an albuterol and nebulizer even to this day because of that. And I have the documents for that. So then let's just go ahead and see what it do then, because you hurt my daughter. And so
Well,
if you're not going to be fair to me, then let me just go ahead and sue for what you owe me.
okay, well, that's what I'm asking is you have the documents to show what you've paid or what you've been billed for your
Yeah,
daughter's care.
I do.
Okay, that's what
I mean, for me to calculate, it's roughly like $12,000. But for me to, I would
ma'am,
have to sit here and calculate
but
because I
that's the
don't have. I'm
ma'am,
sorry.
you came to court based on your counterclaim.
Yes.
So you got to be prepared because this is the time when you have to prove your counterclaim. What you're saying to me is, I got a court date. It's taken a long time, so you had plenty of time to prepare. But once I'm here at the court date, I don't have my records together, and I can say it's about. But what I'm asking you for is like actual numbers. Like, what did you pay for her health care? What did you pay to
Well,
doctors? What did you pay to the emergency room? What did you been? And I'm not asking what was covered by insurance. I'm asking what was billed to you, whether insurance covered it or not. What were the actual numbers billed? What doctors did she see? What that's how you make a claim, man.
well, yeah, I submitted all of that stuff in my claim, but to go in and look at the actual numbers, I mean,
That's the only way I can make a decision is they've given me actual numbers. They've given me the ledger that shows what payments were made or not made. They've given me what they claim is the credit that they gave you. But your countersuit is related to this, but I can't use the same numbers because your countersuit is based on numbers that you say were occasioned by the mold in the home and the so if those numbers I gotta have
you know,
in
so
order for you to make your claim.
not just the numbers of what I spent for medical, but for pain and suffering and all of that as well.
We're not
And
even there
her,
yet, ma'am. First
well,
we start with
okay,
actual damages before we get to pain and suffering. What are your if you have no actual damages,
I
then you
do.
can't get pain and suffering.
Yes, I do have actual damages. One is for $2,279.05.
Okay, and where was that to?
That was to um, Piedmont Laboratory, Radiology, and Emergency Services.
When was that when did that happen?
This particular one is 12623.
And whose name is on it as the patient?
Paris Player, my daughter.
Paris? Okay.
Yeah, Paris Player.
All right. All right. Do you have another bill?
Yeah, $209.05.
Okay. And
This is
who was that to?
Piedmont Urgent Care.
Okay. And what
Date
was that for?
date 1/30/23. Office visit.
Okay. Did she receive any treatment that came with that office visit?
Yes, the treatment is in. Um, I submitted it to your office. All the treatments. These I had to bill separately.
So when you have a claim or a counterclaim, you can submit them to my office, but they have to be on the record. So both sides have the opportunity to hear it and to if the other side wishes to dispute anything. So
Well,
even if you send them to my office, you still have to prove your claim on the record.
okay, yes, ma'am.
Mhm.
Um, this one, this one is from These are from 2022. Looks like the very first time was June. No, March. Um, uh, Looks like 8/25/21. 1/11/23 wasn't right. That was the date it was received. That's not the date that the service was.
What was the date of service?
8/5/21.
Okay, and what was that for?
Oh, wait, shoot.
Your Honor, I'm going to object to the extent, not only to hearsay, but I think even more importantly, there was a renewal lease, I believe, between the parties, and
Okay, so I
Okay, her
have,
counterclaim,
not,
Mr. Bolden, I'm trying to understand your objection because her
not
counterclaim is not,
she renewed the lease September
okay,
the 8th, 2022. So anything prior to that, I think certainly needs to be excluded.
okay.
um,
Notwithstanding the
well,
general objections to not having seen any of this, but I understand.
can I say anything or no?
Well, okay, first of all, let me ask two questions. One, when you say you sent it to my office, does that mean you filed it electronically with the clerk of court?
Yes, ma'am.
Okay, so Mr. Bolden should have access to that.
Yes, ma'am.
All right,
And
number one.
can
Oh, hold
can I
on,
just,
hold on, hold on. Number two, Mr. Bolden has made a point, a motion for having anything after September 8th, 2022 excluded. Reason being, that was the time when you renewed the lease, and that would have been your obligation to mitigate any damages that were accruing. So if you knew that your daughter was suffering from the issues in the house prior to that, and you still renewed the lease, that means that anything prior to that you're in acceptance of because you
no,
decided to stay.
Your
no,
Honor,
ma'am. No, ma'am.
Mr.
Hold
Mr.
on,
Ricky,
Ricky.
hold on.
Hold on, Ricky.
I can't talk to both of y'all at the same time.
We did not discover my daughter. She does have medical bills prior to that because we didn't even discover the black mold poisoning in the wall until December of 2022 after the lease was signed is when First Key first discovered the black mold in the wall. So as she was getting sick through the year and missing school at Kennesaw State, failing because she's sick, coming back and forth, this was before we knew. But when they actually broke out the wall and looked, then we knew that that's what, because when she went upstairs, it went away. So we knew, so the stuff from before, she was sick before. Is that what you were going to say, Ricky?
yeah, we had no idea that there was black mold in the house at that time.
Okay,
But
when did you all kind of discover that there was an issue that you needed to alert the First Key about?
December.
Okay, December of 2022.
Yes.
Okay. All right.
December
All right. So
2022.
to the extent that your objection is to any damages accrued after the renewed lease, the court will overrule the objection to the extent that anything from December 2022 forward will be at least considered by the court with respect to the damages. All right, go ahead, ma'am.
Okay, urgent care charges, $533.10.
When was that?
Date of visit for this one is January 13th, 2022.
Okay, that one's not gonna count.
January of that year?
That was before you renewed. And that
No,
was before you knew that there was mold.
that was before I knew it was mold.
Right.
We didn't discover it was mold in the room until December. And the only reason we discovered it is because we walked in there and it was just, we walked into what was it, water in the floor and in the carpet or something we were doing in the carpet?
Miss Player, let me ask you this. So y'all moved in initially in August of 2020?
Yes, ma'am.
So, and you lived there through that first lease period,
Yes.
and then you renewed for the second lease period, and
Yes,
none
ma'am.
of this happened during the first lease period.
There was a little bit of dripping, and I think they came out and fixed it, which was in the kitchen over the kitchen table. But we just thought it was like, we thought the roof was leaking, and maybe it was something that had to do with the roof.
And
But they
but
fixed
also,
Hold on, sir. Hold
okay.
on. Okay. All right. Did you have any other bills?
Yeah. Here's player, what date is this? 21. Uh, Says applied to date. Well, I don't think that would help. Paris player applied to date would be $2,259.81.
What was that figure? And
What was that again? $2,259.81. That
And
was for what
81.
now?
That it doesn't say, it says applied to date.
No, that sounds like a credit, maybe from a insurance. That doesn't sound like a bill.
Okay. I just printed out everything from the benefit site from everything we spent. So
Okay, do you have any medical costs? I mean, any prescription costs like nebulizer or asthma pump or anything?
I mean, I always have copays. So
Okay. So it's just what I mean, Miss Player, is pain and suffering under the law doesn't come unless you have actual damages. And you got to prove the actual damages before the court can even get to the point of considering anything related to pain and suffering. So that's why I'm taking you through this, because you got to show that you had actual damages that were caused by the mold or anything.
I have actual damages as I can pull in from the Kennesaw State University, where she was missing so many days because she was sick. So she ended up leaving that semester. She failed like almost everything, and she was a straight A student on a scholarship. And it was all her excuses to her teacher were her being sick. So her whole first semester went out the window. I paid $36,000 for her to go to Kennesaw State University. So, and she did have a scholarship for the Atlanta scholarship. But I mean, that's considered a damage to me. It's considered a damage to me that she still has to be on these asthma and nebulizers. Isn't that considered damage?
If it were caused by the home, that could be. Yes, ma'am. Okay. Did you have anything else at this time?
No.
All right. Mr. Bolden, did you have any questions for Ms. Player?
No, I just want to verify that you don't have any qualification or expertise in mold, do you, ma'am, or licensing or
In mold?
mm-hmm.
No.
AMG?
But the people who First Key acquired did.
Okay.
They were mold
Right.
specialists.
And
They were mold specialists.
you don't have anything here that you don't have an expert or any kind of medical personnel to connect any causation of that organic growth in that house during the time period your daughter was there to your daughter's health?
Well, other than the doctors, no, I don't.
You don't have anybody here to testify to that? Okay.
No, other than
No.
your ledger that even acknowledges that there were black mold poisoning. They were aware because your experts that you sent to the house indicated that that's what it is. That's why it's documented in writing.
This is your claim, and so I just want to make sure
Yeah, but your evidence supported that.
I want to make sure that just crossing T's and dotting I's is all. Okay, thank you, ma'am.
Yes, sir. Your evidence supported that. So
Okay. All right, so the total, did you have anything else at this time, Mr. Bolden?
No, ma'am.
Ms. Player?
No, I can't think of anything else.
All right. So, Ms. Player, I hate when people go away feeling like they've been ill-treated by the justice system. So I try and explain things as I go. And I've been doing evictions a long time. I was in magistrate court for 4 years, and I've been in this job for 8. So when I say I pretty much know what I'm talking about when it comes to Georgia law on evictions, I'm pretty good at it. So the issue is people assume that they can just stop paying rent, and that because they stop paying rent, they're going to get all of these, I guess, benefits or bonuses from, because things aren't working from the side of the landlord. So we'll just stop paying our rent. There's almost no scenario under Georgia law where you can just stop paying rent if you're in possession of the property. So the way it works is if you're in possession of the property, you owe the rent and fees and all of those things. And like I said, if they fail to fix whatever should be fixed to make the home livable or to fix any problems, then you can do it yourself and charge them, which would be an offset against your rent. Or you can bring in your own company, pay them, and that will be an offset against your rent. So I don't know of any other situation where you can just not pay. The other option would be that if you felt like the house was so unlivable that you were forced to move out, then that would be what's called constructive eviction, and you could sue because of the constructive eviction, meaning that the house was so bad, I had to move, and because I had to move, all of the things that flow from that, we can talk about in court, and possibly there will be either an offset or, a credit to or an offset for all of the rent or even damages because you forced me to move. Okay. But in this case, you stop paying the rent, you don't have anything in writing that says that they were going to clear the debt. But what I understand is at the magistrate court hearing, they were willing to clear the debt in order for you to vacate the premises. The sticking point at that point was you needed more than 7 days to vacate the premises, and they weren't willing to give you the 7 days. So you all were at an impasse, and then the case came to me with your attendant counterclaim. Now, like I said, the amount owed is the amount owed. So through November 1st, that amount would be $64,696. Mr. Bolden didn't want to admit, but AMG, when you talk about something organic caused by water, I mean, come on, that's mold. I don't know if it's black poisonous mold because I don't have anything from either side that says that. But mold in any form can cause respiratory issues, even if it's not black poisonous mold. Mold growth in a home can cause respiratory issues and those type of things. And so you have you stated on the record that you have some bills that were accrued because your daughter had to go to urgent care, that she had to start using a nebulizer, that she may have had some respiratory issues, but the maximum amount of those seems to be about a little bit like in the $3,000 range. But I hate to keep emphasizing this part, and I know you say that it was because the credit wasn't applied that you couldn't go anywhere else because it seemed that you had the $18,000 that you still owed.
Exactly. I have documentation of them denying me.
The issue is you did owe it, and so it was your choice to stop paying the rent. Under no legal there's no case law, there's no statute that said that as long as you're in the house, you don't have to pay rent. You're required to pay the rent. And so anything that prevented you from moving because you owed the money, it's because you didn't pay the rent. And because you had months and months and months where you didn't pay, you could have, like, you should have been saving that money and you could have paid them off and moved or paid for another house. That all of those are all because you stopped paying the rent. And I hate it for you, because a lot of people think that that's the fix for whatever the problem is. I'm going to just stop paying the rent. That's the worst thing that you can do.
Mercy.
Because if you had moved, like if you had been paying the rent and you moved and you sued them still for this, you could have gone to another place, still had your credit intact, and still, if you wanted to pursue claims against them, you could have pursued them under a civil claim, not an eviction. But
so it
as long
doesn't
as
even matter that they had filed for $10,000 and then voluntarily dismissed it, saying that they filed in an
Ma'am,
error. Does
ma'am,
that not show?
people dismiss evictions all the time. We've had people dismiss evictions because they can't take. So if they file an eviction and somebody pays something, they can't take the money. If they take the money, then the eviction is invalidated. They may have filed it for the wrong amount. If they do that, then they dismiss the claim. If they decide they just don't want to pursue the eviction because they know that things are behind and they're not going to get a hearing anytime soon, that people dismiss evictions for all those reasons and more. So I can't.
The apology letter at 12:48 in the morning, Judge. The apology letter from First Keys manager at 12:48 in the morning. That don't mean nothing either.
But
With
ma'am,
the $10,000
okay,
saying that I owe.
okay, let me ask you this. So at that point, when they said that we're gonna move this eviction, and your assumption was I no longer owe this $10,000. What about the rest of the $54,000 that has accrued since then? You just thought that you'd go and live there with and not have to pay rent?
Once we went to, no, that's not what I thought. Once we went to the court and they dismissed at 10,000. Then we got there and they were dismissing at 18,000. We went back and forth. I didn't know that we was going to take this long to have to go back to court.
They didn't
go before
dismiss.
state court.
You all couldn't reach an agreement.
I wasn't even under contract. I'm not under contract with them.
Does
I'm not
not
even
matter.
under contract with them.
Does
So
not
you're telling me about a year, like I don't even have a lease. I don't know the amount to pay. And not only that, Your Honor, I
Okay.
didn't even get to tell you. I never even told you. I don't even have access to pay the rent. I don't have access to pay the rent. I don't have access to pay any of that stuff. I can't get in on any online portal or do any of that stuff as of now. I'm not even under lease. I'm not even under lease agreement with them. That
So
lease ended.
I feel
And
like
then,
I'm
how
teaching
was I supposed to
dispossessory
even?
because I taught it at New Judge School. So I'm going to teach it to you, Ms.
Yes,
Claire,
ma'am.
and
Teach it
to
to
everybody
me.
else who's listening. So please, ladies and gentlemen, if you are listening, if you would ever want to lease an apartment or anything in the future, listen to me. Under Georgia law, if you are in possession of the property, you have to pay the rent. If there's an issue of maintenance, you have to give notice. After giving notice that issue is not repaired, you have the right to repair it yourself and charge for that, which would be an offset against your rent. You also have the right to pay somebody to do it, which would be an offset against your rent. And you always have the right to move. And it's an issue of I'm breaking my lease, then you can tell them there's a maintenance issue, and this is why I'm being forced out of the home, because there's no longer a place where I can safely live. Okay, so with all of that being said, if you are past the point of your lease and you're still in the home, you become a tenant. You are still a tenant, but you do not have a lease. So you travel under the lease terms that you signed under, which would mean that you would owe the same amount of rent, you would owe the same late fees, you would owe the same utilities, and until you moved out. The landlord at that point, if you did not have a lease, would have to give you 60 days notice for you to leave the property. So they would have to give you 60 days notice saying, hey, we want you out of the property. You, on the other hand, would have to give them 30 days notice saying we are leaving the property. Either of you, either side can break the agreement that you have, even though you don't have a lease in writing, you have a tenancy at will, I believe it's called. And so at that point, they can give you 60 days to leave and you have to leave, or you can give them 30 days saying I'm leaving, and there's no recourse for them as long as you've not damaged the property. Okay, so
So
Ma'am,
does that mean the
the-
amount that they say that I owe is not the right amount if they did it based off of the terms that weren't from the original terms that I originally signed, and it's based off of some new term of 2,500 when my original term was 2,000?
okay. The amount that he has pled for is $2,035 a month. So they did
Oh,
not go up on your rent. That's what he
oh,
stated at the beginning, and that's what the ledger said. I looked through the ledger. Every time there was an amount for rent that was charged, it was $2,035. So number one. Number
okay.
two, so you are under a lease, even though if you haven't signed one, as long as you agree to stay in the property and as long as they keep accepting the money. So you could have paid the same way. If you got to a point where they weren't accepting your money, you could have sent it to them to the address of the business office by certified mail as an attempt to pay. But once they file an eviction, they're not allowed to take the money, because if they take the money at that point, it invalidates the eviction and you go back to square one. So they can dismiss if they wish to, but if they file an eviction and they are intent on getting you out, then at that point they cannot accept money. They can only come to court. Now, the other thing is, the reason that they agreed to wipe the slate the last time was because in magistrate court was because they really just want possession. And I got landlords all day, every day. They don't fight about the money because most times they know they're not going to get it. But they do fight about possession of the property because as long as you're in it, they're not making money from new tenants. And they know they're probably not going to get the money from you all, even if they sue you for it. So even if they get a judgment, they're not going to get it. So they'll say, we'll give up our judgment just to get property back. And like I said, unless you are on good terms with them where they're willing to give you more than 7 days, I can only give you 7 days. If they're not willing to give you 30 days to move your mom and all of that, you have to think about the fact that you've had almost a year since the lease renewed. You could have made those provisions in that period of time because you weren't paying the rent, ma'am. You could have bought a house in that period of time. $35 a month. That would have been a nice little down payment, and you could have bought a house. There's plenty of them out here that you could have
I
bought.
just feel like I was bamboozled all the way around.
No,
And
ma'am.
I'm sitting here looking like what the
No,
people, squatters. Now you got me sitting here looking like a squatter or somebody that, and
ma'am.
you
I'm
know,
not. I'm just explaining to you how it works, and you always had the opportunity to seek legal counsel. I've had to give it to you here, but
yeah,
you were fighting on what you thought your knowledge of what it should be. But you always have the opportunity to seek legal counsel to assist you in your claim and counterclaim. What I'm telling you is this is how the law works. And for a lot of people, especially people who come from New York and other places up north where it's more tenant friendly, that's not how Georgia is.
well, no, I'm from Georgia, born and raised Georgia Baptist. So I guess I don't have an excuse.
Just saying. So, and I stand firm. And I even pulled my book to make sure this is the book. See it? See how big this book is? This portion of it is on leases, leased stuff. So I even pulled my book. Like I said, I taught this at New Judge School, so I'm pretty clear on what's going on. And so the issue is going to be, I'm going to issue an eviction. I can only give you 7 days. If Mr. Bolden's willing to give you more time, fine. But I hate to see people squander the time they have. We're fighting to fix something that the man told you wasn't going to be fixed. At that point, you should have been making plans to get out of the house.
If I could have, I would have. I got, like I said, I had several denial letters, and it's because it looks like I owe first key. Even from back when they've been saying they've been giving me the credit, I got 9 different emails. Like, I can't go anywhere. You got me stuck here. Then what you want me to do? So,
But imagine the leaseholder, I mean, the owners of the property. you all have been there long enough for them to have $64,000 that they can't collect.
Okay, but imagine my daughter who has to breathe on breathing machines and asthma pumps and who failed her first semester at Kennesaw State because of the negligence of the people that they acquired in that house. And for them to come and tell me they're going to give me a credit, I'm sitting there like a dummy waiting on this credit. I'm the one initiating all of this
But
contact.
I'm just going to say one more thing. When you get a credit usually means that you've paid something and somebody credits you against what you paid. You didn't pay anything. So what credit were you looking for?
They were saying that they were going to credit me in advance. Like they were going to credit my account. I wasn't going to have to pay rent for at least the next 6 months based off of the stuff that I brought to the office with the legal team. They already they had went through it. They had agreed to it.
And
All
a
of the
legal
above.
team produced nothing in writing.
Of course, yeah, no. All I have is the writing them saying they're going to give me the credit. I'm sorry, the credit still hasn't hit the account for you.
How much
Here's
is
the renewal of the lease. They even
and
want to give me the lease.
nothing says what the credit is. No number.
My bad on that one. So
I once had a guy tell me that he was sleeping with the property manager, and she told him he didn't have to pay rent. I couldn't. That first of all, that's an illegal thing. But second of all, I was like, look, if you don't have anything in writing that you don't have to pay the rent, the lease still says you got to pay the rent. That's what I have to go by. Whatever that last lease term was, the fact that you're in the property, you got to pay the rent. That's it. Just know for next time, you got to pay the rent. So at this point, the court is going to give possession of the property back to first key plaintiffs, finding in favor of plaintiffs the amount owed through November 1st. And the court can only give 7 days for the eviction. 7 days would include the November 1st date. Judgment will be for $64,696. Because there's an acknowledged claim of AMG in the home, the court will give a $4,000 offset. So it'll be $60,696 for the judgment. And then the writ of possession will be signed, and you have 7 days to vacate the property. Mr. Bolton, anything?
Judge, I would just ask that the order include something that would require her to pay that amount into the registry if she files an appeal.
Okay, so ma'am, if you file an appeal of the court's order, the money has to be paid into the registry prior to the appeal being filed. If it's not paid, then the appeal will be dismissed.
Okay.
All right. Okay, Mr. Bolden, do you have an order if you want to present that to my staff attorney?
I'll present it. I'm about to be in another hearing, Your Honor, at 1:30
That's
in
fine.
Gwinnett here, but within 24 hours.
Yes, sir.
Okay.
All right.
The last thing I'd ask is how do I get a copy of that book?
You got to be a magistrate to get that. Shoot, I had to hold on to that. They wanted it back when I left. I was like, nope.
I don't get it. I don't understand why this mom didn't move as soon as her daughter got sick, and she claims it's because of the mold. That was not really proven. But, very, very possibly. But if that is making your daughter so sick that she's got to drop out of school, she's got to lose scholarships, she's got to lose the money that she paid for school, why not just leave? Why not move right then and there until before you ran up a huge bill? So yeah, they're going to look at the past and see, oh, you owe this other renter, this other place that you were living, a whole bunch of money. Well, if you had moved when the problem first surfaced, then you wouldn't owe a whole bunch of money and you'd easily be able to find a place to live. Or is it that you just wanted to live for free? Because, and Judge Hayward misspoke when she said the last time she paid rent was December of 2022, and she's coming up on a year. No, she's coming up on 2 years that she hasn't paid rent. So yeah, that's going to rack up a huge bill. But your daughter's getting sick. Why not move? And then at the end, we find out her mother lives there, and her mother has breathing issues, is on oxygen. So, hello, don't you think you should get your mother out of the house too? I mean, that's nuts. And just moving to a different room does not fix the illnesses, because you turn on your air conditioner, you turn on your heater, and that goes all over the house. So you're breathing it no matter what. Just move. I don't get it. That just blows me away. Anyway, thank you guys so much for watching, and I'll see you next time.